To succeed in any case brought in terms of our law, one must be correct on both the facts and the law. The facts. In my previous exposition, I alluded to the fact that the Nkabinde inquiry has not properly defined or tested the facts relating to Advocate Chalk's conduct. Instead, much of the inquiry's time has been spent probing issues relating to the Cato Manor unit, the law. In this episode, I will briefly discuss the legal principles relevant to the inquiry. It is important to emphasize, once again, that the Nkabinde inquiry differs fundamentally from commissions of inquiry such as the Zondo Commission or the Madlanga Commission. The latter are established under the Commissions Act. By contrast, the Nkabinde inquiry is constituted under the National Prosecuting Authority, NPA, Act. Inquiries under the NPA Act have a narrow scope and jurisdiction, as they apply only to senior NPA officials. The Nkabinde inquiry as a creature of statute. A creature of statute is a body created by legislation that has no inherent powers. It may exercise only those functions and powers expressly conferred by its enabling statute. Any action that exceeds those powers is ultra vires, unlawful, and subject to judicial review. For example, in Agrella 6 General Dealer CCVGLB, the court held, as a creature of statute, the respondent is bound within the confines of the enabling statute. Once it goes outside the scope of the statute, its conduct is ultra vires. Is the Nkabinde inquiry a creature of statute? Yes, the Nkabinde inquiry is a creature of statute. It was established by President Cyril Ramaphosa on the 29th of September 2025 under the authority of Section 12(6)(a) of the NPA Act. This section allows the inquiry to consider only specific, narrowly defined issues. A senior NPA office-bearer may be removed from office for 1. Misconduct, 2. Continued ill health, 3. Incapacity to perform official duties efficiently, or 4. No longer being a fit and proper person to hold office. Jurisdictional limits of the inquiry. The Nkabinde inquiry does not have statutory jurisdiction to investigate police matters or issues relating to the Cato Manor unit. In my opinion, based on the existing legal framework, any findings by the inquiry that relate to Cato Manor matters would be unlawful. While the inquiry may examine the conduct of Shamila Batohi in her capacity as head of the NPA, it is still bound by its terms of reference. For example, to investigate Batohi's conduct, a complaint would first need to be made to the President. The President would then have to establish an inquiry with specific terms of reference addressing her conduct, and the affected official would need to be properly notified of the allegations. This process would be similar to a disciplinary hearing. In my view, because the Nkabinde inquiry was established specifically to investigate Advocate Chalk's conduct, it is procedurally unfair to examine Batohi's conduct without following the required process and without amending the terms of reference accordingly. Advocate Naka's evidence. Why did witnesses such as Advocate Nako not go to the Zondo Commission, the Madlanga Commission, Parliament's Ad Hoc Committee, or IPID, since these were and are the forums specifically created to investigate police and criminal justice system issues? Why did she, as the officer of the court, wait 10 years before lodging a complaint at Cato Manor? The Makgaro inquiry had a similar mandate to the Nkabinde inquiry, so why did she not reveal this evidence during the Makgaro proceedings? In my view, we need to be very cautious in assessing her evidence. Conclusion. Based on the reasoning set out above, I remain of the view that, in its current form, the inquiry risks becoming a waste of time and taxpayers' money. Any adverse findings against Batohi or relating to the Cato Manor unit are likely to fail under judicial review. This is because the inquiry is a creature of statute and therefore cannot lawfully investigate matters that fall outside the jurisdiction conferred by the NPA Act.